So hi everybody, my name is Jules and I'm the Sales and Marketing Manager at SMATS Group. I'd like to welcome you all to our webinar this afternoon, Australian Residency Tax Changes and Tax Implications for Expats. I'd also like to welcome our friends and co-hosts from AustCham Taipei and Japan, as well as AustCham Korea, Thailand, Laos, Mongolia, Beijing, South China and West China. And we've got a special mention to Julian Lawrence, the chairperson of AustCham Mongolia. Hello.
Hi.
As well as Alex Matos, the executive director of AustCham Taipei. Hi.
Thanks, Jules.
So for those of you that aren't familiar with SMATS Group, we're international leaders in providing Australian tax, finance and property services to Aussie expats, foreign investors, as well as intended migrants to Australia. And we've been doing so since 1995. We've also been recognised as a top 100 accounting firm by the Australian Financial Review Awards in 2019 and 2020, and hopefully in 2021. So before we kick off, if you do have any questions during the webinar, please simply type them into either the Q&A area or the chat room. And we'll endeavour to answer as many of those towards the end of the webinar as possible. So now I'd like to introduce the founder and executive chair of SMATS Group, who'll be presenting tonight, Mr. Steve Douglas. Steve is a chartered tax advisor, a fellow of the Taxation Institute of Australia and a registered tax agent. So over to you, Steve.
Thank you, Julie. Okay, well, I've got the pleasure of taking you through some of these issues affecting us in regards to residency, and it's certainly a hot topic, you know. And before I start, I'd just like to do a shout out to all the chambers, you know, Julian and Alex and co. You know, they do an extremely important job, you know, out in our international communities, and they're keeping everyone connected. So we greatly appreciate them joining us today and helping us get the message out. And I'm sure we're all about to link arms and do what we can to try and get some sensible outcomes in all this residency issue. I'm just going to bring up my slides and we'll get straight into it. I know everybody will be quite anxious. So let me just jump in. Okay, and there's a fair bit to go through. I mean, obviously, all of this has come about in recent time thanks to a little notation in the budget, you know, saying that there was going to be some changes to the residency. And of course, you know, the rumour mill's going crazy, everybody's nervous and worried. So hopefully today we'll provide a little bit of clarity, a little bit of conversation, a little bit of thought and a bit of action, you know, that we can do to help ourselves going forward. So without further ado, I'll get straight into it. And I'll just start obviously with a disclaimer. Obviously, you know, these are, you know, personal views. Please don't act on these without getting personal advice, particularly because they're not yet law. So don't panic or anything like that. Don't go and sell anything. Don't go and do anything crazy. Calm, relax, wait and see what happens. That's probably the real message of the day. So you just think about that. So let's start with what's going on. And basically what we've got is the outcome of an initial review in 2017, and then a report, you know, going through that review that was submitted in March 2019. Now that's gone and done an extensive look at the residency issue, and the government, you know, like I say, in the May 2021 budget around about 6 weeks ago, put a little paragraph saying, look, we think we should just, you know, look to implement these. Importantly, both of these reviews were done in a pre-COVID world, and I think that's an important thing to remember here, because they're talking about number of days in Australia, mobility, all these things that used to be very free and easy in the good old days. But now, of course, we're all living with COVID. We're now into our 18th month in COVID. It certainly impacted lots. I, for example, am a COVID refugee still in Perth, dying to get home to Singapore, but, you know, just can't do it. Every time I'm about to leave, there's an outbreak. They keep talking about bubbles. You know, air costs have gone up, movements there. I've got to get permissions. It's not the same world we knew 18 months ago. It's a crazy old situation, and that has a massive bearing on some of the things that were discussed in the review and the report. I also want to reiterate absolutely categorically that as at today, which is basically 29th of June 21, these are not yet laws. These are proposals. It's a discussion paper. We have not even seen legislation. And that's very, very important, because I have seen already some people saying, oh, get a ruling, get this, get that. You can't get a ruling for something that is not yet law. You know, we don't even know what the rules will be. We don't know what the potential for the wording will be. So do not go and jump off the boats, you know, in expectation of what may or may not happen until you actually see what's coming down the line. You know, it's very, very important to keep a cool head. As a reference point, the earliest that this will come in will be 1st of July 2022. Now, in the budget, they did say it would come into effect on the 1st of July in the financial year following getting royal assent. Now, that was unlikely to happen prior to 30th of June 2021, so it may happen over the next 12 months, or it may even take another year longer. Interestingly, in the report, they have clearly stated that their recommendation is to allow a long period of implementation. So the Board of Taxation, who prepared this report and have made these recommendations, they themselves are suggesting a long line of transition. So it's important not to worry about it too much too early, but especially until we see the legislation. What they're trying to do is good old-fashioned simplification. But of course, simplification to the market and the general community is a very different concept to simplification to government and taxation department. They're trying to make it easy, but in doing so, they often make it hard. Now, some of the things that they'll talk about, you know, today, you know, you'll see are actually positive steps in the right direction. Others are backward steps, and probably where we'll end up is hopefully somewhere in the middle. One of the big changes is the 183 days test. Now, that has always been there, as you'll see in a moment, but it used to have the commissioner with some level of discretion. They want to take discretion out and just say very simply, if you're in Australia more than 183 days, you are a tax resident. And that is quite logical in all truth. So that shouldn't be of great concern to most people. What is of concern is the second test, which is what they call the factor test, which kicks in if you are potentially in Australia more than 45 days. Now, this has been the most, you know, contentious issue because 45 days used to sound like a long time, but it's not anymore. Not when you factor in quarantining, when you factor in the high cost of travel, when you factor in the difficulty of mobility. 45 days is now a very short period of time. So that's something we'll touch upon later, and is probably something that we really want to cluster as a group and target for change, because that's probably the real area of problem with these, you know, proposals. And interestingly, what they're trying to remove is the intention to remove intent. They, you know, the whole crux of the residency laws up until now has been, what is your long-term intention? When you're leaving Australia to become a non-resident, are you intending to live overseas for a prolonged time? The ATO uses 2 years as a measure. If you're coming to Australia as a resident, are you intending to live in Australia for a long time? Intention has been the central point of residency law for almost since day one. And that's what they're trying to get rid of, because intention is subjective. Now, I want to just highlight the fact that the residency issue is not the only problem we've been facing as expatriates. This has been an ongoing issue for many, many years. We've currently got big problems with pensions and superannuation, where the ATO has been suggesting that they're not going to treat them as genuine retirement schemes if you could access it prior to retirement age of 60. They're saying if that's the case, they want to tax you on it as an investment rather than as a pension plan. Interestingly enough, what's happened during COVID is the government has allowed everyone in Australia to be able to access their superannuation, you know, as a COVID booster shot. Now, theoretically, under the ruling that the ATO has given out, that means every single retirement fund in Australia, every single superannuation fund is now not really a superannuation fund, because the ATO's contention is if you can access it prior to retirement, it is not a retirement scheme. So it'll be very interesting to see how they adjudicate that one. Of course, recently we had the big disaster, I call it, the removal of the principal residence exemption, you know, for anyone that lived in their home, regardless of how long that may have been, if they sell it while living overseas. Now, this has been a real bad law and really should be repealed, but we're not having much luck. We managed to get it delayed, but we haven't got it repealed. Now, this is a problem because any expat should not sell their former principal residence while living overseas. You should absolutely sell it when you go back to Australia and are living in Australia, not necessarily in the house, but in Australia. But this is something we need to fight too. And of course, in 2012, we lost the 50% discount on capital gains on investments we held in Australia that were taxable, such as property investments, etc. Now, this was, again, I think, very unfair. It discriminated against people offshore and versus onshore, and was a massive disincentive. It hasn't stopped us investing, but it certainly is unpalatable and unfair. And of course, we've seen big issues on offshore bonuses. If you're transferring back to Australia from working abroad, bonuses and benefits that come in after your return, even if they relate to periods of living overseas, are taxable. That's an issue. And employee share schemes is a whole big can of worms that we're looking at the moment. So there's quite a few issues that we've got to deal with as expatriates, for tax, and these all have to be considered. It keeps my head certainly spinning on a regular basis. But residency is one key element, and it's obviously the issue of the day. So let's have a look and see it. Well, I suppose we'll start with the question of why are they simplifying it? Well, to be honest with it, I think the main reason they're simplifying is because the Commissioner's not getting his own way. The Commissioner has been quite aggressive lately in just dismissing people that have genuine circumstance abroad and are genuine non-residents in order to capture them and try and tax them. Now, he's been losing cases left, right and centre and having a really, really hard time at great expense to the management, because bear in mind, the ATO usually hires in outside barristers when they have cases. So they're not happy with the results. And instead of abiding by the rulings, they're doing the next best thing for them, which is change the law. We're of course seeing a changing world, where circumstances that were not foreseen many, many years ago are becoming normal, such as families being apart for various reasons, economic, emotional, at the moment for health. We're seeing people being able to work remotely, so it doesn't really matter. You can take extended periods of travel because being away from the office isn't as difficult as it used to be. And of course, we were, up until COVID, a highly mobile society. Personally, I used to travel 30-odd weeks of the year. That seems crazy now. I can't remember what it was like to hop on those things called airplanes. It's just like an old-fashioned thing now. But, we would hope that sometime in the not distant future that mobility returns. Otherwise, we might not have any aircraft, but we'll see what goes on. But all these issues have changed it, and the tax office has been slow to adapt, and that hasn't helped. And as a result, they think the old rules are becoming obsolete because they don't want to, morph into the future. Now, interestingly, the Board of Taxation called their report the modernisation of, residency rules. So they're trying to lead from the front and get the ATO to follow, but they're doing it with some common sense and a little bit of, I think, problematic, positioning. But they're the main reasons why they're looking to simplify. If we have a look at what it's all about, here is a quick snapshot of the residency issues. So I've tried to condense this as best I can. Hopefully, it means that you're not going to be too overburdened mentally. But the current rules are on the left-hand side. And the current rules basically say that if you're in Australia more than half the day, you're going to be a resident. But you can see there in white, the big factor is unless the Commissioner is satisfied you're usually living overseas. Now, that's important for someone like myself who's stuck in Australia, where my home is in Singapore. I've still got it. I haven't rented it. I haven't sold it. I haven't cancelled the lease. Everything's there. It's very obvious I'm going home. So the Commissioner would rightly say, oh, well, Steve, even though you've been stuck here for ages, your intention is to go back to your home in Singapore, and therefore he can treat me as a non-resident. Now, the problem is he'll argue the point. So I have to then prove it to his satisfaction. He's very rarely satisfied. So that ends up being in a dispute, and we have to go to the umpire, being the tribunal or the courts. Now, it comes under a very simple, statutory test in theory, but as simple has become complicated. Resides, where do you genuinely live? Domicile, where is your main area of existence? And the 183 test is more a tie break than a determinant. So if all the other things are a bit cloudy, where you are the most of the time can be the decision, but it still is very much a subjective test based on the facts of the case. And this has been very frustrating for the ATO, because the facts are different for everybody. So they have to reinvent the wheel, reassess, reapply, rethink, and that's really driving them nuts. Now, the only easy test is the Commonwealth Superannuation test, which means if you're an employee of the government and you're having contributions as an active member in a superannuation fund of the government, then you are a resident. So that usually counts for people being posted overseas into embassies or on foreign assignment. If you look at the proposed, I suppose finishing off there, the residency always has, commenced or ceased based on the day your intention changed. So when you intended to move from Australia overseas or overseas to Australia, that day of intention change was the date your residency changed. So notwithstanding, for example, someone like myself who might be stuck here, if I end up getting frustrated and say, you know what, I'm sick of this, I can't wait any longer, I don't want to go home to Singapore because it's too hard, I'm now going to stay, then that day that I make that decision is when my intention changes and is when my residency would change. And that's always been the case. And of course, you would want supporting evidence, etc. So it becomes subjective again, and this is where disputes arise. What they're proposing is to basically have the 183 days full stop. So they're saying if you're in Australia for more than 183 days, you are resident. No questions taken. And that's sort of makes sense. I mean, it's a bit unfair to someone like myself, but you can understand the logic because they're tired of this whole subjective argument and debate and, tossing of the coin and proof of this and denial of this. It's all getting too hard. Now, importantly, they are sensibly proposing, and again, we'll wait to see the legislation, that the 183 days would exclude any days where you're stuck in Australia out of your control. So they use examples that a volcano erupted, because, pre-March 2019, that was about the only time you wouldn't travel. But guess what? COVID's here. So now everybody's travel is out of their control. There's rules, there's, restrictions. It's a crazy situation. So they'll have to have a good definition of what is out of someone's control. But obviously things like quarantine, etc., you can apply. Now, they're also talking about excluding things like if you're coming back for a family illness or for a specific, matter out of your control for compassionate grounds. So that, again, we'll wait and see what that definition is, but those things would be excluded. So the 183 days, in essence, is not such a bad problem, okay? I don't have, generally speaking, a problem with the 183 days and the exclusion. But the big issue, and this is really, really the bone of contention, is that if you're in Australia for more than 45 days and less than 183, it opens the door for the Commissioner to apply a second test called the factor test to determine whether or not he considers you to be a tax resident, even withstanding that you've been in Australia less than 183 days. Now, this is where the can of worms really explodes, because they're talking about making it nice and simple, this test, not subjective, just absolute. And in doing so, they have proposed at this stage to have 4 simple questions. The first one being, do you have the right to reside permanently in Australia? Well, for an expatriate, that's an automatic tick, because by the nature of an expatriate, you are an Australian citizen or at least a permanent resident. And, the only people to be excluded from the right to reside permanently were people on temporary residency visas. So if you don't have the right to live forever in Australia, that's the only one that's going to be excluded from this test. So every expat, tick, 1 question right. Australian accommodation is they're saying that you've got access to somewhere to live that is not a hotel. Now, that doesn't mean your mum and dad's house, but it could mean a rental property you have, a holiday house, whatever the case may be. So most people might have that, particularly if you're staying longer, which is happening these days because travel is so difficult with quarantine, etc. It's very, very difficult to stay for just a week or 2 like it used to be. People are more likely to elongate their trips and more likely to have a holiday home that they can stay in. It might be rented out on Airbnb while they're in absence. They're also looking at your Australian family there. And this is obviously, relating to your immediate family, your wife and children under 18, because this is addressing the split family situation. So they are very obviously targeting that group where you're working abroad and your family is there. Now, again, it won't apply if you're less than 45 days in Australia, but 45 days is not that much. And then the fourth test is Australian economic interests. And that would include things like a substantial bank account, which they have not defined, but probably 50,000 or more. You know, it would include taxable property, which is basically just investment property. Now, shares, you know, investments, they're not taxable Australian property. You don't pay as a non-resident tax on shares. So they've been excluded. But one thing it does have as a catch-all is a family trust, etc. So if you've got a family trust, that will capture you. Now, again, I don't want to be alarmist, and I will just remind you that it only applies this test if you're in Australia more than 45 days. Now, to get potentially captured as a resident, the problem is you only have to say yes at the moment to 2 out of 4 of these questions. And given that everybody is allowed to be there permanently, and probably everybody's got an investment property or some level of activity, you know, investment down there, it's pretty easy to go, yes, I am, you know, therefore grabbed under this measure. And that's why this is such a bad test. This is a loaded deck against every single Australian expatriate. And it's really, really poorly done. It's too simplistic, you know, and at 45 days, it's a bad example. Now, the 45 days has allegedly been considered by the fact that most people have 4 weeks annual leave. So that's really what they based it. They said, oh, okay, if you've got 4 weeks annual leave, that's 28 days. You know, if we add a couple to that, 45, that should be fine. That should be fine. Well, the problem is that, you know, it's easy to go over 45 days, especially in a post-COVID world, you know, where maybe the quarantine is included, maybe it's not. We don't know yet if that will be outside of your control or inside of your control. You know, it's going to be more and more difficult, like I say, to do short-term trips. So most people, because of the expense, are likely to stay longer, and 45 days would be it. Now, one of the things that I look at is not how much holidays the individual may have, but if you look at a simple measure that I think would be more appropriate is look at school holidays. You now get 8 to 10 weeks of school holidays. So that would be more appropriate a measure than, say, 4 weeks of annual leave. You know, and particularly because a lot of contracts allow that. And particularly now with mobility being so easy, where you could say, look, I'm going down and visit my family, my extended family for Christmas. Because it's so difficult to go, can I stay 2 or 3 weeks extra? I'll work from home while they're all mucking around during holidays. So to me, I would have thought a more appropriate measure would be school holidays rather than work holidays. So this is the thing that we really, really have to focus on for change and improvement. You know, the last test there is the overseas government official test. That replaces the superannuation test and basically just means if you're working for the government and you are deployed overseas, you will be a resident. Now, that's no change. That's always been the case. Anyone working on Australian, you know, embassies, that's counted as Australian soil, and you are always have, and this will continue on, as a tax resident when you're working on Australian soil or you're off on an Australian government project. Now, the last thing that I've mentioned is residency commences on the first date of arrival. You know, and there's a quirk here that also says that you can't be a resident unless you're in the year for more than 45 days. So the quirk is if you arrived on the 1st of June, you would only be in Australia 30 days. In the old rules, it would start on the 1st of June being date of arrival, date of change. You know, but under the new rules, they're saying that if you arrive on the 1st of June, you're only in Australia 30 days. You stay a non-resident for that 30 days, which is a little bit nonsensical. Now, they have mentioned that in their paper. They have said this is a bit strange. Maybe the government might want to address that. I hope they do, because it seems odd to have that sort of weirdness. But importantly, where it is got even stranger is their assertion in the examples they're giving is if you might have popped down to Australia in August to just do a pre-reconnaissance, look at a property, visit friends, do a bit of business, and you stayed for 2 or 3 weeks, and then you don't come back until June or May the following year, and you then stay and you move in, that gap between the August and the May trip, if you go over 45 days, they're going to treat it as if you moved to Australia in August, even though that was just an exploration trip. So that too sounds a little bit weird for me. Something needs to be done to bring that more to their attention and fix it. But overall, the key here is that the 45 days is the killer. And, people might think, oh, that's a reasonable time. That's their assertion. They think 45 days, that's generous. But I don't believe so, not in the modern world, pre and post-COVID. It is very common for people that are particularly expatriates to have jobs that are regional. They have jobs that require them to travel backwards and forwards. Pilots alone would probably do more than 45 days in Australia just in arriving and departing. So that needs to be looked at very, very carefully. On another level of that is the fact that they're trying to also make it harder for people to become non-residents. So they're bringing in a concept of a decent residency, where if you've been a long-term Australian and you want to go overseas, they don't like it for you to just say, click, I'm now a non-resident from the day of departure. They don't feel comfortable with that. They feel you've had too much benefit and it should be a progressive thing. Now, they've done it in two splits. They've done it here as what they call the overseas employment rule, where if there is a specific expat situation where you get a job overseas and you leave, if you have been living in Australia for the 3 prior years as a resident, then to become a non-resident, you must have at least a 2-year employment contract that cannot be from a family-related organisation. You must have genuine accommodation to stay in that place of occupation. But most importantly, and to me, most difficultly, you have to spend less than 45 days in Australia each year that you're working abroad. If you do more than 45 days, you would lose this benefit as a non-resident and you would be potentially taxed on your entire income overseas. Now, that's a massive problem, and hence these 45 days sounds long, but it's quite soft in my mind, especially if you're in an original role, especially in a post-COVID, hard to travel environment, especially in a world where you might want to go back, for family or whatever the case may be. I'm very concerned about the 45 days. If you're not going overseas under the employment rule, if you're just deciding to just go and relax and just move overseas as a retiree, for example, then it gets even a little bit tougher, because you will not be considered a resident until you have been in Australia for less than 45 days for at least 2 of the previous income years. So the fact that you move overseas, if you did not do that as a result of getting a job, then you are not going to be automatically entitled to getting non-residency status the day you leave. It's going to be carried forward until you've been away for up to 2 years. Now, they generously will give you a foreign tax credit if you're paying tax or earning money in that foreign country, but that can be an issue for you. So you've got to look at that. It's going to be more complicated, not less complicated than the current rules. But again, this is probably aimed at people that travel. If you go overseas for an extended 1-2 year long-term holiday, that's going to be the fact that your residency won't change. But the strange thing is, under the current rules, that would still be the case. You'd have to show that you live somewhere overseas, in order to break your residency. If you're just traveling, that doesn't change residency under the current regime. Now, if there's a double tax agreement, which Australia has with many countries, but not everyone, then that would override these residency rules. So if you were deemed to be a resident of both places, the double tax agreements work in essence to allow the country where you earned the money to be the one that is allowed to tax you, and you would be excluded from the other. But what happens, and what they propose to change, is currently, if you're in a double tax agreement situation, you're deemed to be a resident of both places. And what that would do is that would still continue to afford the 50% capital gains tax discount, for example. And what they want to do is change that to say that if you are entering or benefiting from a double tax agreement, then they want to flick you to be a magical non-resident and lose things like that 50% capital gains tax concession. Again, probably unfair, hard to argue though, they're probably going to get this one through, but I think that's probably against, again, all of our many years of proof and law, but we'll see what happens. The other example they use is what they call a short-term resident, where someone who has been overseas came back to Australia or migrated to Australia. So if you've been resident for less than 3 of the prior years, so you've been there 1 or 2 years, then you don't have to worry about staying a resident if you leave. As long as you spend less than 45 days in Australia, your residency would cease on departure. So that's going to help some expats, that's going to help some migrants that come if they decide to go back overseas. But again, that's not a very high proportion of the general population. So this to me is still an issue. And again, it comes back to this 45-day test whatsoever. So 45 is going to be the most important number in the expat world for the next 2 or 3 years. Now, again, any government employees that are deployed overseas, they will remain resident, as I previously mentioned. That's not going to change, nothing really there to worry about, and that's always been standard and sensible. They are making it a little bit better to confirm and clarify that if you just work for an Australian embassy because you happen to be in the country, i.e. they did not send you there, they're confirming and clarifying that you're not on Australian soil and not taxable for that income, you're taxed on local tax. But apart from that, everything is pretty much it. But you can see how critical these 45 days are. And that's really what we've got to focus on. Now, this is just for the sake of example, one of the things that I've put together as an alternative to the 4 simple tests. This is the ATS suggested factor test. Now, again, they're up for this. In the report, they have said that they would look at an alternate points-based factor test. And that to me is far more sensible because it allows you to give appropriate weighting to certain things. So you can see here, just as an example, the fact that I'm a citizen, a resident, or a visitor has a different weighting. The fact that I'm intending to be overseas 1, 2, or 3 years, that I've been away for a certain period. All these things are relevant in determining this. And again, I've been doing this for 25 years. So this is some of the key elements that are there. Now you could add and subtract, you could modify these to the cows come home, but this is really a far more simple system. And if they acknowledge and agree with expats through the chambers, through the likes of us, through appropriate communication with the likes of us overseas, then we would be able to have a situation where we would feel comfortable in that test, where it would be more relevant to everybody's circumstances. So in this particular case, if you got 16 or less, you would be a resident. And I've just given some examples there of what would be. So someone obviously, there's definitely a non-resident on the right-hand side, might own their property overseas. They intend to be away indefinitely. They're heavily weighted issues, whereas someone who's only going away and living in a serviced apartment and will only be away a couple of months, that person is heavily weighted to be a resident. And this is far more appropriate in the modern age to reflect all of these things. So something along this line would be a far better situation and one we should be collectively putting forward as an alternative. Now, I suppose, what can we do from here? I've given you a brief outline on what's going on, but what we can do, well, we have to obviously respond to the government report with a detailed submission of our own, and we will do that. So, expect us to get that out in the next week or two. And what I would like you all to do is endorse it. Say yes, that's fine. We also want to get a petition going. So I've already lodged that with the government, and basically the petition at this point, because we are limited to 230 words, is basically saying, please, sir, do not use the 45 days as the base. We don't mind the 183 days, but please lift that 45 days. I think it should be towards 90 days. But, if it's going to stay at 45 to 90 in that range, then we have to specifically state to exclude things like quarantine, to exclude things perhaps like going down on business. It is madness to make it detrimental for any Australian expatriate to want to go back to Australia for business purposes, to expand the Australian economy, interact it and make it into a global powerhouse. That seems absolutely lunacy, and it goes It flies against everything we've all believed in as expatriates. And of course, we have to get together as a powerful voice, at corporate, at chamber, representational, at industry level, and all of us individually get together, hold hands and say, this line can't be penetrated. We need to make sure they're very clear and understand how important this is. Now, again, we've tried this in the past without success. So we need to be better and stronger than ever before in doing this. This is why we have to go forward. Now, this is my recommendations as to what we should do as a collective. I think we should accept that the 183-day rule is likely to be passed and effective. And it just means that life does get simpler if you remove those subjective tests. Now, it may disadvantage some, but at least it gives clarity to all. We need to adjust that factor day test. Like I say, extend it from 45 to 90. Look at the 8-week school holiday period as being the measure, not the 4-week annual leave period. Look at excluding COVID quarantine and get rid of those genuine business days. And then what we want to do is get that expansion, a test like mine or somebody else's, anything that is better than just 4 simple trick questions that capture all. Get that point score, get the appropriate weighting. It's not hard to figure out if you open your mind and think about it. And again, we're not talking here about issues that are against the intention of the report. The report has stated they're happy to have that point score system. They think it is a genuine alternative. They thought the 4 questions were simpler, but that's probably because they're government department people working for the government, recommending to the government on behalf of the tax office. So if we talk about industry and individuals with representation, I'm sure we would have got a different outcome. Now, we need to get this fighting fund going, and that's what SMATS has been talking about for a while. We're ready to launch it. So we're going to ask you all to put some cash in the pot, because this is not going to be easy and it's not going to be cheap. I've fought all of them previously myself and didn't really get far enough because we didn't have the power to get into the right places. But last time when we were having issues with the principal residents, SMATS did contribute to AustCham Hong Kong, and got a delegation flown down to Canberra, got in the right doors, and at least it bought us some time, and they made some important changes to bring in some hardship provisions. So we achieved a great result there, albeit not good enough. We wanted even better than that. But if we want to get better, we need to have the cash and we need to have the fund. So we're suggesting we all tip in a couple of bucks. Doesn't have to be much because there's loads of us. If we chuck in a couple of bucks, let's get a fund to lobby, educate and submit. Let's get out there and help the chambers to do the contact that they need, help them with resources, help them with travel costs, help them with support material, whatever's required. And importantly, what we also need to do is use this fighting fund to pay for some of the poor people that go first in their tax cases. One of the big things that the tax office relies on is that the cost to defend a challenge from the ATO is massive, hundreds of thousands of dollars. Now, if you are, for instance, contesting this residency issue on what should be excluded or whether you change your intent or not, you could rack up thousands of dollars, but the tax difference might only be $20,000. So if you were going to save $20,000 of tax, but it was going to cost you $200,000 to prove it, you're more likely to say, forget it, I'd rather pay the 20 grand than take the risk of the 200 grand of legal fees and then have to pay the 20 grand anyways if I lose. So the tax office basically buries us in cost to submit, and they go, great, we won that one. Well, that's just not on. That's not the way to do it. We need to have it so we've got a fund that if you are the poor person that goes first, that we can be funded and it doesn't come out of your pocket. And therefore, when your test case gets success, it's shared with everybody. We can say, there you go, Johnny's case is now the basis, and therefore we've got that success going. Now, this is going to be prudent and important, not just for residency, but very critically for all these retirement funds that are going to be challenged in the next few years. If you're coming back, it could be you. And unless you've got unlimited deep pockets to fight this, having something like this is just a salvation for us all. And of course, we've got to go in and argue these residency test changes, redraft the law and get clarity on the superannuation and fix up things like the ESS. There's all sorts of things, but we need to have a single place to do that. Any funds we raise will be kept aside. They'll only be used to cover the professional costs associated with submissions, lobbying, attendance, hassling these people, traveling to Canberra, for both us, barristers, chambers, whoever's necessary to get down there. Again, the chambers have been massively successful in the past because they get the door open. We need to get them there. Now, that may not happen for a while whilst we've got the borders closed. They may all be on Zoom, so we'll save a few bucks, but someone has to go. And then, of course, using that money for those legal cases to prove the point, so it's not at the burden of expense of an individual, it's at the collective of the group for the benefit of the group. The Fighting Fund mission, very, very simple. Let's encourage the government and support them to get this simplification working. But let's re-expand the definition of simplification to a normal man's simplification, not a government department's simplification. They're very different. Let's do it through clarity and understanding. Things like a proper test, things like communication as to how you're going to do it. Getting that 183-day accepted is fine, but the 45-day trigger is totally unreasonable. Let's go and fight that. We need to have great communication points. We need to, this report should have been contacting the chambers and the likes of SMATS first, not last. They're the people that are affected. They're the people that have the answers. No one was consulted or talked to. We need to protect those people that are singled out, because if you're that person, believe you me, it is a horrible place to be. It's stressful, expensive, and it's downright bullying that you'll be lucky to survive. And then we've got to get these issues remedied. Now, we're not going to do it just by yelling. We're not going to do it by thumping the table. We've got to have a good common sense approach. We've got to have a justifiable argument, be well informed, well resourced, and we've got to deliver a message. Now, again, we can't do that as one. We have to do it as all. The chambers are critical in this. They have the open door. The individuals are critical because the power of the masses is important. And SMATS is prepared to drive this and make it happen because we've got 25 years experience dealing with these matters. And hopefully you think we know what we're talking about. So we'd like to invite you to join us, fix these changes before they're too late. Let's not put anyone at risk of 45 days triggering a massive tax bill for no reason other than bad legislation. So hopefully, I'm not trying to worry you because this is not yet done. We have a window of opportunity to fix, remedy, and make sensible. If we do it together, I'm sure we can get a result on that. So hopefully I've given you a little bit of a view of what's going on, giving you a little bit of energy to join the fight and see if we can fix this, because you can't just sit on the sidelines, people. We've got to step up and go for it.
Thank you so much, Steve. I think we've received more questions and in the Q&A and chat room than we've ever received from any other presentation. So yeah, you've obviously been very insightful. Thank you to everybody that has sent us questions, and I do apologize in advance. We're not going to be able to answer them all because we've literally been sent, almost 100. It's been a really great response. If we don't get to,
most of them have been answered along the way.
If we don't get to answer all of them, just rest assured that we will send everybody a copy of the webinar, and Steve and I will record a separate video with all the Q&As answered, and you'll also receive links either through your chambers or through ourselves with an invite for free initial tax consult,
and the Fighting Fund.
The Fighting Fund, and a link to the petition as well. So that will come out to you by the end of the week. If you do have any other questions, feel free to email me directly, so julie@smats.net, or you can email your chambers and they can pass them on to me. But thank you so much. Thanks, Steve. Thanks, Julian. Thanks, Alex. And we hope to see you at the next webinar.
You had a great attendance. It was fantastic to have so many people join us. So I really appreciate everyone giving up their time.
Thank you so much, guys. Enjoy the rest of your day.